Right, everybody, it's the top of the hour, so welcome to the session of the SLN Conference, Special Needs Legal and Future Planning from a Sibling Perspective. My name is Becca and I'll be the moderator for this session. If your camera is on, we can see you, and if your microphone is on, we can hear you, so please remain on mute. Use the chat box to continue to engage with other attendees. The engagement so far has been great, so keep it up. As a reminder, this session is being recorded and will be made available to SLN members in our online archives. I'll place a link in the chat box for the handouts for this session and the conference handouts as a whole. So we'll go ahead and get started.
Hello, this is Benji Rubin, and thank you for coming to our presentation today. I'm about to start a quick intro, and then I'll be back in just a couple minutes. Thank you. Thank you, and hope your day has gone well, and this conference is getting you lots of great information. So today we're talking about special needs planning. And so the reason that I practice the type of law I do is because my brother Mitch, as was mentioned in the introduction, so that's Mitch, as you can see there. He used to work at our office before the pandemic and hopefully will again soon. We're getting probably within a month or two, he'll start coming in 1 day a week. He also does developmental training and also does work with a job coach through his group home and his agency that runs his group home called Clearbrook. That's a picture of him obviously in his Clearbrook attire. I'm the president of Supporting Illinois Brothers and Sisters. We're the Illinois chapter of a national organization called the Sibling Leadership Network, where there is a resource for brothers and sisters that have a sibling with disabilities. Obviously you're here with Sibling Leadership Network. So I want to make sure that you're aware of our state chapter if you happen to live in Illinois. I don't have to educate you because you're here because of SLN, but we have our state chapter. Obviously, there's SLN has chapters throughout the country, and hopefully this conference will connect you with your local state chapter. And if it is Illinois, please connect with me afterwards, and we'll make sure that you get involved with our state chapter. You already have all this information from the conference, but again, our local chapter in Illinois, sibsnetwork.org if you happen to live in Illinois. All right, and that applies if you're a sibling who lives in Illinois, but your brother or sister with disabilities live in another state, or vice versa, whichever the case may be. If you want to get involved in Illinois SIBs, please don't hesitate to reach out. And if you want more information about SIB shops, things like that, for younger siblings, etc., we have resources on our state chapter website. I'm sure SLN also has some great resources for you as well, and our adult sibling group information as well. So what I'd like to talk about, when we talk about future planning, okay, we're talking about from a sibling perspective. We want to include siblings obviously as early as possible. And many of you, of course, have tried to encourage your parents, if they're still living, to include you in that planning process. Hopefully you've been successful in that. But we want to have government benefits be the base, the widest part of this pyramid for our brother or sister with disabilities. But if we leave an inheritance directly to them, they're going to lose those benefits. So it's really important that mom and dad, or grandma or grandpa, or aunt or uncle, but mom and dad are the primary people who do this, don't leave money directly to our brother or sister, but rather leave it for their benefit in what they call a special needs trust. There's actually two different kinds of special needs trusts, and they both are important for different reasons, but it's important that they're distinguished because they have different rules, and so we don't want to confuse the two. All right, and they can still work. Okay, my brother works now. He works in the community with a job coach, as I had mentioned. Half the time, the job coach does a job he watches, but he's hopefully getting he's getting out there and doing things. This is all pre-pandemic, and hopefully we'll be again in the next few months returning to that. But there are individuals obviously with disabilities of all kinds that are your siblings, and they may be able to work way more than my brother works. Okay, we have many clients who work way more than my brother works, but it's important to know there are certain limitations of how much you can work before it affects benefits. If they don't work too much, they can have their work earnings or inheritances in a special needs trust and still have government benefit eligibility. So we talk about what you do. It's not just actually what mom and dad do and grandma and grandpa do, but siblings can mess things up too. We've seen it happen. So if a sibling, God forbid, passed away or made a gift, obviously it can make a mess of things. So we have to be aware ourselves that we have to make sure our planning doesn't accidentally interfere with our brother, sister's government benefits. But we also really need to make sure that parents and grandparents and aunts and uncles don't mess things up, and especially our parents. So how much does our brother, sister need the rest of their life? It's impossible to know an exact dollar amount, okay? We talk about talk about like planning for college education, for example. We'll look at what the next, inflation or return on investment will be for the next 15 or 20 years, right? When we talk about planning for our brother or sister with disabilities life expectancy, it could be 60, 70 years or more. So it's impossible to know an exact dollar amount of what they're going to need the rest of their life and what government benefit programs will even exist, let alone what they qualify for, all right? So given that, where's the amount of money they're going to come from? Well, we expect that they will work to an extent. Now, some states actually take that seriously and really pursue individuals with disabilities working in the community. For example, in Washington State, if you happen to hail from that state, they actually have over 80% employment rate for people with IDD, which is wonderful. That said, state like Illinois or some other states, we're way below that, probably under 20%. So, in most cases, not working that much. And even if we are, like my brother, probably not working enough to support themselves financially. And that's okay, because mom and dad are going to live forever and support them forever. And we all, as siblings, know what that plan means. It means that it's up to us to be there for them when our parents can no longer do it. And that's not really, I would say, a good option. It's not fair, not only to us, but it's really not fair to our brother or sister with disabilities. We should have a plan in place that should have to set us up for success. So let's talk about government benefits 101. Okay, we start with SSI, supplemental security income. The Social Security for someone who doesn't have a work record and is disabled. They have an income and an asset test. And prior to age 18, they look at both parents' assets and income. So in most cases, our brother or sister doesn't qualify until they're at least 18 years old. The asset is $2,000 and it hasn't changed since 1971. And they go back 3 years. So even at age 18, they no longer look at parents' assets and income, but they do look at the child's assets and income going back 3 years. So if there's a custodial account or savings bonds from grandma, that's going to count against their $2,000 asset test. The other test is the income test. That's the disability test. Do they have the ability to earn, in today's dollars, $1,310 a month? Okay. Now, it's not like unemployment compensation. They're not going to say, prove to me you couldn't get a job. They're going to actually look at diagnosis, medical information, all this stuff, IEP, school records, appropriate social functioning, activities of living. Could they sit and scan tickets at a movie theater 8 hours a day, 5 days a week is a classic example they might get. Now, this is a federal program, SSI, so across the 50 states and in all of our territories. So, it's the same rules. There's different regions that implement it, but there's the same rules. And assuming they get through this, and many of our siblings probably already have gotten through this. If you're coming to this meeting, your sibling may be an adult already, and so they have SSI, and they're getting $794 a month, maybe. Okay, now some states have an add-on because they say that's not enough. And some states, probably majority of states now are not as generous, and they say, no, you're going to get the federal minimum of $794 a month. So that's basically what you're going to get is what the feds get, $794 a month. And if they are going to live at home with mom and dad, it's going to be reduced, as we'll see. But even forget that, if they start earning income, they reduce the SSI. After $85 a month, they lose 50 cents on the dollar after $85. So if they earn $285 at age 23 when they're done with school, they're going to start losing their benefits. When they're still under the school umbrella until 22 in most states, we're talking about they can earn a lot more money. But when they're done with school after 22 and they age out of special ed, they can't earn more than $85 a month before their SSI gets affected. But luckily, they'll probably not be on SSI for very long, or for most of their life at least, because they'll eventually be on SSDI. So what is that? Social Security Disability Insurance. That's Social Security for someone who has a work record and is disabled. That's the traditional way to get it. So we all have Social Security records. We've been working, presumably. We can build our quarters. You have enough quarters, you get your Social Security check if you, God forbid, became disabled by accident, for example. Now, our siblings can actually get it on their own work history. So, for example, if my brother got SSI at 18, but then he started working, and by the way, there's a special rule. It's SSI is not, there's no SSI eligibility until the first day of the calendar month after you turn 18. So people get tripped up on that. You can't apply on their birthday. You have to wait till the next month. But quick side note there. But SSDI can be obtained on their own record. So my brother, if he worked for enough quarters, okay, and a quarter with a credit, it's kind of complicated, but it's 1470 is the current number this year. If you earn 1470 in a calendar year, that's 1 quarter worth of credit. If you're in 2 quarters with a credit, that would be 20. That would be double that. Okay, so like 29, 40. So basically, and upwards, up to 6 to 4 quarters in a year. And 6 quarters is what you need before age 24 to get a small SSDI check. If your siblings are already over 24, they're going to need more than 6 quarters to get a small SSDI check. Kind of complicated how it works, but the important part to know is that they can build their quarters through work earnings, and they don't have to earn that much. Just 1470 in a year gets them a quarter worth of credit. Of course, if they earn too much money, more than 1310, they're off benefits entirely. There's another way for them to get SSDI though, and that's the way my brother got it. My brother never earned more than a couple $100 a month, but he has DAC status, Disabled Child or Child Disability Benefit status. The way this works is that so long as they get SSI before 22, or they're at least deemed disabled prior to 22, easiest way to do that is to get SSI before 22. Then when a parent goes on a Social Security retirement, disability passes away, they get to go on the parent's Social Security record and get more money, okay, based on the parent's Social Security history. This is going to be a very large sum of money, okay? It's 50% of what they call the primary insurance amount, which is the amount of money the parent's entitled to at their full retirement age, which is usually 66 in a certain number of months, or eventually will be 67, depending on what year the parent was born in. Now, that's great. It won't happen until they retire, probably, unless they became disabled or passed away, God forbid. Number one, it's 50%. And also note, when they die, when the parent dies, they then will go on to 75%, up to 75% of the primary insurance amount. To give you an idea of the types of dollars we're talking about, a max Social Security record, so let's say they were a dentist or something, for their career, that parent was, the child will go get 50%, it'll be about $2,000 a month in today's dollars. And when the parent passes, they'll get about $3,000 a month. Okay, so it's significant dollars we're talking about here. But key thing to note about this, if they ever earn over $1,310 a month, they call substantial gainful activity, or SGA. If they ever do that for more than a month, or even do it for a month or two, they jeopardize their ability to ever go on a parent's work record ever. Okay, so it's a big problem that people don't realize, that they try to get a job, they try to work full time, or even a significant part-time job, and they mess up their entire lifetime benefits right there. So be very careful about that. Now, once you get SSDI, either on their own work history or on a parent's work record, eventually when the parent retires, hopefully, and doesn't become disabled or pass on, they'll get Medicare 2 years later. So 2-year clock starts. So for example, my brother got SSDI when my father took Social Security retirement at age 66 in however many months, but he didn't get Medicare till 2 years later after that. Even though my father had Medicare at 65, right, before he even got Social Security, my brother's Medicare didn't start till 2 years after my father took Social Security retirement. So it's a 2-year clock from Social Security retirement on the parent's record. And by the way, if both parents have significant Social Security histories, when one parent passes or when one parent retires, they go on that parent's record. If the other parent had a bigger record and retired later, they'll switch to that parent's record. They can only be on one parent's record at a time, but they get to be on the highest parent's work record. All right, and again, 2 years after they get SSDI somehow, some way on their own record, parent's record, they got Medicare 2 years later. So SSDI and Medicare don't care about assets. Okay, they could have millions of dollars in their name, won't affect their benefits, but they're SSDI and Medicare. But SSI cares about assets, and to get set up for this whole thing, you got to be an SSI generally. And then Medicaid cares about assets as well. When it comes to Medicaid, I just realized I didn't mention, SSI has a special rule if you don't charge rent or a fair share of household expenses and they're living with you or with family, and you're not charging them for that. SSI reduces by up to a third of their SSI of $794 down to $529 in today's dollars. SSDI does not reduce for that. But going back to Medicaid, Medicaid is crucial because Medicaid is much more than medical. It's what pays for group homes and day programs and job coaches. They call home and community-based services waiver. It's also a backup to private insurance. Okay, so no co-pays deductibles. Quick side note: I just like to brag when I have something to brag about with Illinois, because Illinois is notoriously bad when it comes to services for people with IDD and generally people with special needs. But we really have a great law in Illinois that no one else really has, which is that we can stay on our brother or sister can stay on our parents' health insurance forever if they're disabled. And that's pretty cool. So just like to brag about that. But again, it doesn't apply outside of Illinois. But if you happen to live in Illinois, item number 4 on our information request form, which I'll be sending to SLN to make sure that you can access it. We know we can't leave money directly to our brother or sister, because it'll mess things up. And if our parents don't have will hours for them, and it says half goes to our their spouse, and then half goes to their kids, and that's a problem too. We're not going to disinherit them, hopefully, and leave everything to us, because even if we're the best people in the world and we trust ourselves, what about our potential ex-spouse? What about a IRS or creditor problem? We don't want to do that and risk the money for the benefit of our brother or sister. So we also talk about traditional trust that people use sometimes until kids are older. That doesn't work with a child who's going to be on government benefits. So special needs trusts, okay? There's 2 kinds of special needs trusts, as I mentioned. Third-party trusts for gifts and inheritances. There's a private version drafted by an attorney and run by a trustee who's appointed by the parents. Usually the parents initially are the trustee. There's also a pool trust. That's a nonprofit organization run trust. There's also a other kind of trust that is not as friendly, called self-settled, first-party, OBRA, D4A, or payback trust, also private and pooled versions of this kind of trust, but it's not as friendly, hence the sad face, and we'll talk about why. What both trusts have in common is their reserve funds over and above government benefits. So while they can't have more than $2,000 in their name, they could have $5 million in a special needs trust and it won't affect their benefits at all. So third-party trust has been around for a long time now, okay? By court decision in the early to mid-'80s in most states, by state and federal statutes in the 90s, okay? So it looks like this is inheritances, gifts, life insurance, retirement account, beneficial designations, but never, ever, ever can their money go in here. I can't emphasize enough, including, by the way, child support payments cannot go into a third-party special needs trust. What can, again, inheritances, gifts, life insurance, things have to have a direct line from the parent, grandparent, even sibling, aunt and uncle, to the special needs trust. Nothing can touch the child's name. Once the child has a right to it, or it has some association with their social security number or their name, it's tainted and can't go into this trust. Then when our brother or sister passes away, if our parents set up the trust, they can decide where it goes. We've actually had siblings set up these trusts, and they would then, setting it up, they get to decide where it goes when their brother or sister passes, okay? It's not going to go to the government, and that's a key part of a third-party trust. It should not be inside of the parent's will or living trust, okay? And that across the country, you see a lot of us attorneys will do it inside of a parent's will or living trust, and we don't want it that way for a number of reasons. We want to exist now, not only when both mom and dad pass away, and one of the reasons for that is we call piggybacking. Why? Well, what if grandma or grandpa outlives mom or dad, and now they want to leave money directly to, and they want to leave money directly to actually the opposite. What if grandma or grandpa passed away, they want to leave money directly to the special needs trust? Trust has to exist, and it won't exist till mom and dad both die. That's a problem. What else? Aunts and uncles, siblings, okay, us. What if we say, hey, we got our first job, we're not married, don't have children yet. We want to make sure the beneficiary on our benefits is our sibling special needs trust. Well, trust has to exist. We can't have it inside of our parents' will or living trust. If laws and rules change, you want to be grandfathered on existing laws and rules. We don't want to gamble that they're not going to, the laws and rules won't change. So the trust has to exist. God forbid our parent or grandparent needs skilled nursing care. General rule is they can't just give their money away and have the state pay for them 5-year look back period to do that. But there's a federal exception. You can actually move assets into the special needs trust for our brother or sister and qualify themselves for Medicaid to pay for their own skilled nursing care. For grandma or grandpa or mom or dad's skilled nursing care. So something to note, but the trust has to be freestanding for that. Also, if people are making gifts, let's not compound the $2,000 asset test issue. So the trust is just a document, right? The trust document is just, it explains the law, the rules of the road. If there's an account, investment, name of the trust, who's in charge of it, who's, the successor trustees, all of that. But the trust can have all kinds of assets, right? It can own stocks, bonds, mutual funds, investment accounts, checking accounts. It can own real estate, account of they're living in, a vacation home. I mean, literally, the sky's the limit with what it can own, based on what kind of, obviously, assets are owned by the trust, what kinds of funds we have available. But it can own all kinds of assets for the benefit of our brother or sister. All right, so how do we get assets into the special needs trust? Well, mom and dad's wills or living trust better say that the share for our brother or sister goes to that special needs trust. We have to get the word out to the extended family, especially aunts and uncles without children and grandparents. Okay, so fill in the blank form, maybe an instruction letter from the attorney that drafts the trust, and trust certification, and that attorney hopefully will consult with the attorneys for grandma, grandpa, or whatnot. But we want to make sure also our own documents and our own beneficiaries are updated if something might go to our brother or sister, it goes to the special needs trust. So, one second. What if there's someone out there, a parent, grandparent, what have you, that doesn't have a relationship with our brother or sister, but they might leave something even accidentally, especially in a divorce context? So we like to put out something called the ex-spouse letter, but just to be aware of this is an issue that comes up sometimes. So we got to set up a special needs trust for our brother or sister. We got to reference it in the estate plan documents for our parents, but not have it included in their trust or will, just reference and have a freestanding special needs trust. We got to get the extended family on board, especially grandma and grandpa. Okay, and we ourselves have to make sure we're on board for it. But we can't forget to change beneficiaries on things. So we have to make sure that our parents or grandparents and ourselves, or if it applies to us, have our beneficiaries updated for life insurance, IRAs, 401ks, pensions of other sorts. Make sure all the beneficiaries are updated. All right, what about gifts? If grandma or grandpa are giving very generous gifts, make sure they don't give it directly to our brother or sister. Make sure they give it to the special needs trust. If it's the $15,000 annual exclusion gift, then there's a longer discussion about that. But if it's less than that, it's like a few hundred or a few $1,000s even, have them read to the special needs trust. So if we're talking about third-party trust, what if we have to use the other kind of trust? Well, how does this work? Well, let's say there's savings bonds from when they were born. There's a custodial account. There's a lawsuit settlement. There was a lawsuit and they sued someone. There's excess Social Security or work earnings, what have you. What do we do? Well, they have money in their name. If it's not that much, we can spend it on things they need anyways, okay? If it's a little more than that, we can throw it into an ABLE account, okay? It's available in Illinois, and there's about 40 states now that have some, either they're part of a partnership or they themselves run their own ABLE program. It's like a 529 or 529 college savings plan, but it's for people with disabilities. You have the $15,000 a year into it from all sources, only one account per beneficiary, and the beneficiary themselves is the owner by default unless there's a guardian appointed. Balance can't go over 100,000. By the way, even if there's no guardian, if you're a power of attorney, in most states that allow you to access the ABLE account if the beneficiary allows for it. But the balance can go over $100,000 if they're still on SSI. Again, most of their life will be an SSDI, so you don't have to worry about the $100,000 cap. But we can't put more than $15,000 a year into it, and there is a cap in each state. The host state's 529 cap applies to the ABLE account. In Illinois, that's $450 for reference. Limitations on how to spend don't really exist anymore because the IRS got rid of them, so you can ignore that part. But here's a key thing to know. The Medicaid, they call it clawback or payback on death. When our brother or sister passes away, whatever's left in that ABLE account doesn't get to go to us or our kids or anything like that. It goes to the government basically in most cases. Now I know some states have tried to, including Illinois, have tried to get rid of the payback, but they can't override federal Medicaid regs, okay? It does grow inside the ABLE account tax-free, but who cares because in the long run it goes to the government. When do we like to consider ABLE accounts? when there's excess Social Security and work earnings. And this comes about a lot of times when we take over, right? Because now our parent has passed away, let's say, and they're getting SSDI. So we have an individual who is maybe more independent, right? They're living in a condo with some supports maybe, and they're getting Social Security, and they're working and making $800 a month, $900 a month, something like that. And they're getting Social Security on our parents' record, right? So now they're getting over $2,000 a month of Social Security, earning, let's say, $1,000 a month of work earnings. That's $3,000 a month. Maybe they have the home and community-based waiver for, they call it home-based support services in Illinois, where they're living independently or semi-independently. So they're getting another, $2,500 a month from that. How do they, if they have excess savings, they can't save it. They'll go over $2,000, lose their benefits. We can't save it in the special needs trust. It'll taint the trust, make it a resource, but we can save it in the ABLE account, and that's what we would recommend doing there. Some states have a Medicaid buy-in program like Illinois, where you can avoid the $2,000 asset test for Medicaid. It doesn't help with some Social Security though, and so all right, not that useful in most cases. Now, the one use for ABLE accounts, maybe we want to give control of some spending money. So let's say we have a sibling who isn't earning that much money. Social Security is coming in, but it's going to us as representative payee, maybe. All right. But we want to give them some control over some spending money. Okay. Well, we can use the ABLE account as that way to do that, because if they're their own guardian and we put money in the ABLE account, they're by default in charge of that ABLE account. So it's a way to kind of give them access to spending money, because the special needs just can't give them distributions directly. It has to pay for things for their benefit, but it could distribute to an ABLE account. There's a game to avoid that 1/3 reduction for housing expenses of SSI. It doesn't affect most of us, because by the time we're super involved, probably our siblings no longer on SSI anyways. Again, what if someone left a little inheritance, $10,000, $12,000 directly to our brother or sister? We could put it in the ABLE account. Lawsuit settlements are another key one if it's small enough. And if they have a 529 plan, we never convert it over, we convert $15,000 a year up to that to an ABLE account. Be aware, if they're working, they can actually contribute their work earnings and on top of the $15,000 cap. So an actual escape valve where they can access extra cap beyond 15,000 if they're working. Doesn't really apply to many people though. But there's this payback. It applies basically to all the Medicaid that really matters, which is home and community-based waiver Medicaid, the stuff that's really expensive. Okay, there's gonna be a payback on all of that. Okay, some states have a state income tax deduction, including Illinois. In fact, I think most states do now. But again, you're not going to contribute to an ABLE account where because you get a few percent back on your state income taxes when you're going to end up having to pay back that money to the government when the child passes. Okay, what about if it's a larger sum of money? So we use a first party trust, which came into law in '93. First party or OBRA trust, D4A payback trust, a lot of different names for it. Because like an ABLE account, there's a payback to the state when the child passes away. So when do we use this trust? Medical malpractice, personal injury settlements. Okay, those are the big ones. All right. When else do we use this trust? Inheritance gifts incorrectly left directly to the special needs to the child directly and not to the third party special needs trust. Okay, or child support payments in a divorce situation. Now, when it comes to medical malpractice, okay, or personal injury situations, if it's like a birth injury case, things like that, please note, because this is something that sometimes parents don't ever pursue it, or they didn't want to pursue it. The statute is told basically if someone has cognitive disabilities, they can basically in almost every state, they can actually go and still sue years later, like decades later, even for birth injury if they can prove it. So just be aware of that. And we've had cases where it was 20 years later, the child's 30 and they're finally suing and successfully for millions of dollars. So just be aware of that. You don't want to obviously go to the person you find on the billboard. We can obviously refer you to people who do this nationally, who do this nothing but those kinds of cases. But regardless, those have to go to this kind of trust. That unfortunately, when the child passes away, the government has claimed for reimbursement what they paid in their lifetime. The good thing is during the lifetime, we get to spend it for their benefit and improve their quality of life. So it's kind of like a free, like no guilt, just spend it. Figure out ways to improve their quality of life. Let's come up with really fun, interesting ways that that they would enjoy spending the money. All right, so first party trust isn't so good for other reasons. You can't use it if they're over 65. Can only be established by parents, grandparents, courts, guardians, or they themselves can set it up if they're their own guardian, which guess what? Does not include siblings. So there you go. Courts often will require supervision over the first party payback trust sometimes, so be aware of that. Child support, if there's a divorce situation where the parents are divorced, child support has to be court ordered to a first party payback trust. Okay, this is the Illinois statute, but there's an equivalent in every state at this point. If you want information, check the box item number 3 in the information request form that will be sending along to SLN after this recording. Now, we don't want to leave money directly to them, okay? And we should leave everything to the third-party special needs trust, all right? And if there's no alternative, do we use the first-party payback trust? So that's a quick summary of that. Nursing home empowerment exception, we want language in the power of attorney of grandma and grandpa, as well as mom and dad and their living trust, so that if they lose capacity, we as their successor trustees or agents can actually move their assets into the special needs trust to qualify them for Medicaid to pay for their skilled nursing care. Some states are required to go to a payback trust. Illinois allows it to go to a third-party trust. Again, another reason, like I said, to not have to be inside of the parents' wills or living trust. This talks about if they have worker and Social Security money, spend it or lose it. If there's an ABLE account or first-party payback trust, spend that money next because there's a payback when you die. And the last thing we spend is third-party trust, because guess what? If they pass on and there's still assets left in that trust, it'll stay in the family. It's not going to disappear. All right. So, if let's say your parents already set up a special needs trust, it's a good thing to make sure that they submitted it to SSI Medicaid and got approval for it. Okay. Because if they haven't yet, it could be a mess on your hands when it gets funded later on. Constantly, the special needs doesn't make it one. We want to make sure the person who drafted it knows what they're doing. There's plenty of people who claim to know what they're doing, but have no clue, as you may imagine. It should have language that says that what laws, rules, Medicaid regulations, state laws, all of that, they're relying on to set up the special needs trust. So if those get changed or grandfathered in, we should prohibit first-party money going in there. It should be 100% discretionary. It should allow for paying money to an ABLE account, but it cannot permit payments directly to our brother or sister. It shouldn't be overly restrictive. A lot of times you see trusts say, you can't use this trust to pay for food or shelter. That's ridiculous because now we can't use it for something we want to use it for. And the reason for that may no longer be valid because they're not an SSI anymore, which is the only government benefit program that cares about who's paying for food or shelter. We also want the trustee to be able to change a trust if laws or rules change, or even if they clarify their interpretation of those laws or rules. We'll talk about next generation trustees. We want to have the ability, what if our brother or sister outlives us? We want the ability for us to add on successor trustees after us, maybe our own children to act as trustee for their aunt or uncle. We've seen that happen, in fact. We want the ability to make contributions to organizations providing services, okay? Most state laws default that the trust can't make charitable contributions unless it's authorized to do so. So we want to make sure that the trust is authorized to make charitable contributions to organizations providing services or that may be providing services to them in the future, to buy goodwill, to get them into a program, and to subsidize their living situation. It's, it all depends on the state situation, how generously they fund the services, but a lot of states, these charitable contributions are crucial to quality services. Gift language. They're going to niece and nephew's birthday party, when a gift coming from, from our brother or sister, that can come from the trust if it's authorized to do so. Also, want to be able to make gifts to staff. Okay, if they're in a group home, we want to make sure that at Christmas time they're getting gifts to the staff, and so that is another thing we'd like to have in a third-party trust. That's rarely in them. What else? What if there's a God forbid a to-be-born grandchild or some other relative that special needs? That's another place, another provision that should be in there to cover that. Again, nursing home empowerment exception is different in each state. Some states allow for their public pensions to go to special needs trusts, which is pretty cool. So we have clients where the entirety of the funding of their of the special needs trust for their brother or sister is coming from mom or dad's pension from working as a public school teacher or university professor in the state university system or a state employee. Okay, very cool, or a police officer or a firefighter. So it's very cool that we can do that. But so a lot of states have been allowing us to do this. Pretty cool. Check into your state. If you're in Illinois, I know the rules obviously, but if you're in another state, check into that. Military pension is the only federal pension right now we can do this with. We can't do it with other civil service pensions, other federal pensions we can't do it with yet. If they're moving states, people are more mobile now. We have to be able to have the ability to change the trust as necessary to qualify under a new state's Medicaid regs, which might be different than our current state of residence for our brother or sister. So that should be in their language to be able to make changes like that. All right. The wills have to have language about nominating guardians in most states. That's where they're nominated, is in the will for who should be guardian for an adult disabled person for our brother or sister. So we want to make sure if we are supposed to be guardian, we want to be nominated in our parents' wills. Living trusts. The parents' living trust has a certain language in there. If parents have irrevocable life insurance trusts, there's certain language in there as well. All kinds of complicated stuff in there for our parents' estate plan. Now, if you want a handbook about how to administer special needs trust, there is a Special Needs Alliance. We have attorneys in 47 states now, I believe. And my father's a past president of the organization. I've been a member for many years. And we have this resource we put out nationally for special needs trust. So if you want that, you can email us for a copy of that. If you want more reading material about special needs planning, item number 6. And if you have trouble falling asleep at night, you can request our special needs trust taxes handout. So, all right. If let's say that mom and dad are going on vacation, Illinois has a form, and a lot of states have something similar, so called a short-term guardian declaration, which is basically delegating mom and dad's guardian responsibility. So if mom and dad are already guardian for our brother or sister as an adult, they can actually delegate to us while they're out of town guardian responsibility temporarily. Okay. Now, obviously, when they turn 18, mom and dad lost all rights to make all decisions for them, and we would have no right to make any decision for them. So it's something that we need to be aware of and help our parents serve if they do need to become guardian. We've had many cases, in fact, where the parents never become guardian because they never needed to, ever invent the rules and talk to them. But when the siblings had to take over, that's when guardianship was required. So be aware of that. It's really important that parents write down letters of intent, guide to educate the future team, writing a book about our brother or sister. All the stuff they have all up in their brains, all the stuff listed here. So that's really important. Where they stay-upon documents are. We don't want to be digging and tearing apart the house trying to find where these stay-upon documents are. One thing we talk to parents about a lot is if you decide to do a prepaid funeral or some other burial arrangements, make sure that we know about it so that for our brother or sister especially, we know what obviously what their desires are, what mom and dad's desires are, but also what already has been planned for our brother or sister, so we don't plan unnecessarily twice over. All right. If you want item number 2, you get a fill in blank form to add to create this letter of intent document. Okay, or you want articles about it, you can check the box for that as well. Again, you'll be sending this information request form to email@rubinlaw.com. Again, email@rubinlaw.com. Thank you very much for listening. I know that I can't answer your questions directly because this is recorded due to when this presentation is being aired, but I am available. You can always just shoot an email to email@rubinlaw.com and let me know if you have questions and I will respond, or you can let SLN know and they'll send forward the questions that you have. Thank you again for listening. I hope that this was useful for all of you to hear, and I wish everyone well. Stay healthy, stay safe, and look forward to seeing people in person 2 years from now at the next SLN convention. All right, thank you very much. Take care. Bye-bye.
All right. Hi, everyone. I know that was a lot to take in. I've listened to his presentation multiple times, and one that was a 2-hour presentation, and we still didn't get through everything. So I've put those, yes, Denise, head is spinning for sure. So I put those links in the chat box, definitely use them. I'll put that email in here as well. Send that request form to that email at rubinlaw.com. Use the resources that they have on their website. That Special Needs Alliance handbook is a must to take a look at. So thank you for sticking it out. And there are, like somebody put it in the chat box, there's another planning for the future as part of the post-conference. So definitely sign up for that. We'll be going back to the main session for mindfulness techniques to enhance well-being, which might be good after this session. So I'll put that link in the chat box for you. And then we'll see you over at that room for the mindfulness techniques. Thank you, everyone.